Happy Monday, and welcome to another episode of cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about logging protests. Cases that should have gone to the Supreme Court of Canada, but didn't. The Teal Cedar case has been ongoing in British Columbia for a long period of time and involves a significant number of protests. After a while, the Teal Cedar company sought an injunction against the protesters to try and prevent them from engaging in protesting activities on the logging roads. As a result of this, the court ordered that the protest activity must stop for a certain period of time. When the injunction expired, the government and the Teal Cedar company sought to renew the injunction, arguing that they should be continued to prevent the protest activity from taking place. The Teal Cedar protesters argued that they should be permitted to continue engaging in the protest activity and that the balance of convenience did not favor a furtherance of the injunction. At the BC Supreme Court, the court looked at certain public interest factors, including the availability of law enforcement provisions, the ability of the RCMP to investigate and prosecute criminal activity, and determined that it was ultimately not in the public interest to continue with the injunction because other methods of controlling the behavior that the Teal Cedar company sought to prevent could have been used by the police, and yet they weren't using them, instead relying on a civil injunction system to perform what it was effectively the duties of the police. The court found that this was not in the public interest. The BC Court of Appeal disagreed and reinstated the injunction, and the matter went to the Supreme Court of Canada and leave was denied. This case obviously raises significant issues about the important balance between a person's protected right to protest as part of freedom of expression, as well as the court's ability to control the actions of individuals vis-a-vis private companies to ensure that behavior that destructs or obstructs the economic activity of those companies is not interfered with by protesters who engage in unlawful or unnecessary protest activities. The unfortunate result of this, though, is that the Supreme Court of Canada missed an opportunity to really get into the nitty-gritty of what the civil injunction system is supposed to be used and how it balances against people's charter-protected interests and rights, particularly where there are other avenues available to government and to private organizations to deal with what they perceive to be the problem, and yet where those are not being used. The Supreme Court of Canada had an opportunity here to further clarify the extent of protest rights as part of protected speech and the extent to which courts can be used by private companies to enforce injunctions against private individuals expressing their charter-protected rights. Hopefully this doesn't take another situation where people who are protesting causes that they legitimately believe in have to go all the way to the Supreme Court of Canada to try and obtain proper protection for Section 2B rights. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada But Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazenville Creative for putting together these videos. Please like, subscribe, and share with your friends.